Check, check. Can everybody hear me? Okay, I just came on. Good evening and welcome to tonight's workshop on estate planning. You know, a lot of times when people hear the term estate planning, they think of some wealthy millionaire who lives in a mansion and drives fancy cars and inherited a lot of money. But the fact of the matter is you don't have to be a Kardashian or a Gates or a Carnegie or a Rockefeller to take advantage of these types of financial planning tools. And tonight, we'll talk about that. Our presenters tonight are Dustin Weaver and Kevin Danley. Dustin is a certified financial planner and financial advisor with MoneyWise Wealth Management with 15 years of experience. He holds a California state life and health insurance license, along with Series 6, 7, 63, and 66 securities licenses. Dustin is a Bakersfield native, and he's a co-host of the MoneyWise Guys radio show and podcast, which some of you have probably heard when you're driving around in the car. Kevin Danley is an attorney with the law office and a partner with the law offices of Young Woldridge LLP. He has a focus on, come on in, with estate planning as well as business formation and planning. He earned his Juris Doctorate from UC Davis School of Law and was admitted to the California State Bar in 2003. Kevin is a Bakersfield native, like Dustin and like me. He is a West High Viking, right? All right. You a West High Viking? Okay, what are you? Oh, she's a driller. Okay. Oh, boy. The rivalry is kicked in already. There it is. And Kevin received his Bachelor of Science from CSU Bakersfield. During tonight's workshop, Dustin and Kevin will focus on the need for careful attention when it comes to managing an estate and conserving your assets. Together, they'll cover estate planning fundamentals, challenges, distribution techniques, trust strategies, important documents, and current tax laws. So, as you can see, there's a lot of topics we're going to cover. I'm an expert on none of them, so I'm going to turn it over to Dustin and Kevin. And just so you guys know, in addition to what's in the room here, we have about 160 people signed up to listen to it via the live stream. So during the Q&A session, I'll have this microphone. So raise your hand, and I'll bring the microphone over because we want to be sure that the people at home are able to hear it as well. So I don't know who's coming up first, but coming together. This is Dustin and Kevin.
Try again.
I'll trade you.
It's green. A little better? All right. We'll get it dialed in here. Welcome, everybody. You just heard the introduction from Mike. I am Dustin. This is Kevin.
Hi, welcome. Thank you for being here tonight. And this is our first presentation together. So we're going to be kind of working back and forth with each other, picking up various slides. And Dustin's going to start us off here.
Excellent. Yes. As you can tell, this is a popular topic. Every time estate planning comes up, I share. We fill a room like this. And then obviously we have several more online. So thank you to Safe1 for putting this together as a complimentary workshop. Safe1's been a fantastic partner in providing education in the community for many years now, and MoneyWise is very grateful for that. So thank you, Mike. So this is the fun slide. Lots of disclosures. Bottom line, we are not here to give specific tax or legal advice. Talk to your own CPAs and estate planning attorneys.
Yes, and I am supposed to say that although I am an attorney, I'm not your attorney. So this presentation does not establish an attorney-client relationship. If you have questions specific about your estate plan, you should talk to an estate planning attorney for a specific advice on those issues. Okay, thanks.
Great. Now we got the fun part out of the way. So our commitment, as you know, alongside Safe1, we're just here to provide some education today. Obviously, everybody here has their own unique and individual goals. We encourage you to just take what you can. And then obviously, if there's specific questions that you have, you could always follow up with either one of us or other professionals that you already work with. But we're here to just provide general advice on the topic of estate planning, which is just one aspect of moving the slides all over. Now, one aspect of an overall financial plan, obviously.
Okay, so I will just disclose that I have a background in education. So in addition to a legal background, so it always feels like the first day of school when all the students come in. I don't know who the students are going to be good and which ones are going to be a problem. So we'll figure that out as we move through here. But I will say that our goal today is to educate, just to make you aware of what some of your options are and what some of the consequences are of the options that you choose for your plan for yourself. So we're not, I never tell someone that they need a specific plan, but I do advise them that they should consider what plan is best for them and their family and their situation. Okay. So, we talk about some of these sort of worst case scenarios, right? So we're all aware that even people with lots of resources fail to plan, right? So, and it's not necessarily because they're, I would say, negligent necessarily. Most of these people are very busy, right? For example, we're talking about Aretha Franklin, right? The Queen of Soul. Well, she has a very busy schedule when she was alive, right? She's on tour, she's doing lots of things, but she did not have an estate plan when she died. And so that resulted in lots of litigation, things going through probate, and also conflict and strife as a result of that, right? We also have the example of Michael Jackson, who, I mean, I don't know how much, what the size of that estate was, but I think I read something like during the process, he did not fund the trust. He had a trust, but he didn't fund it correctly or didn't get everything in there. And I think it brought in I think it was like $2 billion of income, right? I mean, it's a vast estate. And so, so that created all kinds of issues. There was all kinds of expenses associated with that, litigation. So when there's a failure to plan, there's generally issues that you don't want to have resulting, and we don't all have to be, these kinds of, I guess, high profile people with lots of assets to have the need for some proper planning to make sure things go the way that we want them to go. So, there's kind of two aspects of the what we're going to talk about. There's managing assets. We talk about an estate plan for when you die, right, and what's going to happen with your assets. But there's also planning for how things are going to be managed during your lifetime, setting up the right trusted agents that can act on your behalf if you need them to, but then also setting up the proper people to manage things when you're no longer around to manage them, and make sure that they get handled in the way that are consistent with your wishes. So some of the fundamentals we'll talk about, right? You're going to be selecting who's going to receive your assets, how those are going to be distributed, what that plan's going to include, whether it's going to be outright distributions or whether there's going to be milestones or there's going to be age requirements, who's going to manage those assets. So the idea is that we're trying to reduce the time, cost, and frustration that can result when there is no plan, right? Also, if you have minor children, you're able to nominate who you would want to be in a position to take over that responsibility. And then, in certain, instances, it's making a plan for how do we make sure that the person or people that have to manage this have access to resources to help them manage some of the financial issues that come as a result of someone's death, right? There's a lot of times where, it's very sad, but when there's no liquid capital available, the people have to come out of pocket, or they just don't have the money. They've got to borrow money. And so those are the kind of things that you can prepare for in advance.
Yeah, so one of the things that always comes up is what are some of the challenges? What are some of the challenges when we're thinking about creating an estate plan? And the first one that comes to mind is, well, who do I get help? There we go. Who do I get help from when it comes time to create an estate plan? I saw one recently that just, I had to laugh. There's signs that used to be stapled up on the telephone poles that used to say, "We buy houses." And now I've seen a couple that say, "We do estate plans." $250, for a full estate plan. I don't know if that's the going rate for an estate plan or not, but I think it's a little short.
Yeah, it's not typical. Yeah. And to speak to that, there are certain things that you can go onto YouTube and watch and figure out how to do things like, I don't know, replace a compressor in a washer or something like that. But estate planning is, I don't recommend trying to just figure it out on your own. At the very least, you should talk to someone and make sure what you do is going to fit what you want. And a $250 estate plan is probably worth just that, right? So
that's right. And over the course of, I've been a financial advisor for about 16 years now. I've met with a lot of people, and a comprehensive plan, an estate plan, is always part of a comprehensive financial plan. And I've seen a lot of different things over the years. There are online vendors that have popped up in recent years for typically less money than meeting face-to-face across the table from a real life person that you can look in the eye. And I've seen those redone many, many times, where it's often a template. You're doing a lot of it yourself. You go through, answer several questions. They put together a template. It shows up in the mail. And although that's more affordable, I can tell you from personal experience, you're better off meeting with somebody face-to-face. So that's why we put this in the challenges category. It's just not a Google search away. You really want to meet with a professional. So probate, I'm sure many of us have heard that word before. Probate is the process of going through the court proceedings where it's determined where your assets will go when you are no longer here. And so if you don't have things properly documented and, your wishes basically written down, well, then it's up to somebody else to decide what that looks like. And that could be a scary thing.
Yeah. So probate it serves an important function when there is some uncertainty, right? Because you want to make sure that the right people are going to receive the assets of an estate, right? So if you don't have a plan, the state of California has a plan for you. It's called the probate code. The probate code has provisions that they think this is what most people would want to have happen, right? And so it may be that the probate code ultimately is consistent with what you would want to have happen, but by requiring the process of the court supervised process of probate, that takes time. There's expense associated with that, and it also creates in certain instances the potential for conflict with people who don't know what your wishes are.
So you mentioned one of the things that I want to touch on here is it can be expensive. If we were to put a number on it, is there in California an estimated percentage of an estate that the probate can end up costing?
Yeah, so it is hard to put a number on it because it is difficult to know what I guess issues will arise when you start the process. In generalities, I would say that there are some abbreviated processes that like small estate set-asides, those kind of things that are not a full probate. If you hire an attorney to do those things, then you're probably looking at, $4,000 or $5,000 of costs. Larger estates can be, $15,000, $20,000, $30,000 of attorney's fees and court costs, right? So it really varies. Once you hit a certain level, it is based upon statutory percentages that are outlined in the probate code. And primarily those are costs that are going to be paid to attorneys. But administrators or executors are entitled to the same costs that the attorneys are entitled to if they choose to take them. So it could be, even you could double that depending on who it takes over in that position.
And here locally, what kind of time frame is an average probate? I've heard a year, year and a half, sometimes 2 years.
Yeah, so has anybody been involved in any probates here? I mean, well, obviously you're here, so you're not involved in one way, but in terms of the actual process of it, right? So minimally, no matter what you do, you're probably looking at 9 months to a year. That's for summary proceedings and certain kinds of proceedings that involve, even if you did have a trust, but you didn't fund it properly, those kinds of things. If you're looking at currently a full probate, which is, is running between 16 months to 2 years is sort of like, I would say probably I would expect that's the average right now.
And then, correct me if I'm wrong, but it's not a private thing, right? A lot of your explicit details about what's going on with your particular probate in your family is listed for the world to see.
Yeah, so any all of the court proceedings are public. There are certain exceptions, like I think there's certain kinds of, when we're dealing with some kind of minors and guardianships, and some of those things can be closed session, but for the most part, everything is public. And so that means anybody can show up, and that means anybody who thinks they might have a claim or an objection or what have you, can put a wrench in the process, right? And I've seen that. I don't know that I've had it happen specifically with me, but people show up and they say, I don't agree. I don't want that person to be the administrator. And then that can cause a 3 to 6 month delay because the judge is going to give them time to find an attorney and be represented and file their papers and all that kind of stuff.
So probate doesn't sound very fun. Thankfully, there's some ways to avoid it, and we're going to get into that here shortly. But one of the other problems when thinking through just an overall estate plan is a problem that doesn't come up for a lot of folks because over the years, in order to qualify to pay an estate tax has gotten quite large. So currently, estates in 2025 that are $13.99 million for an individual, or just under 28 million, basically twice that, for a married couple. If your total net worth with business and assets and property and everything combined is less than that, you'll avoid the estate tax. So there's good news there.
What's the amount?
$13.99 million for an individual in 2025. And it's been a moving target over the years, but that target is set to change unless the current laws are extended. So in 2017, through the Tax Cuts and Jobs Act, the number was increased and adjusted for inflation up, but it's scheduled to set back unless they keep the rules where they currently are. So what does that mean? There's potential for it to be rolled back to around $7 million for an individual, $14 million for a couple. So for those that it applies to, an estate tax, the way that works, they look at your net estate and they have what's called an estate tax exclusion, which is where those multiple millions come into play. They exclude that from the estate tax. And then if you have a value that's above that number, they would multiply that by the current estate tax rate, which is 40%. So it's a pretty hefty tax for the wealthy that don't go through the estate planning process to potentially get some protection from that. Because there are strategies that you can implement to reduce that. Yeah. So this question has come up a lot for me, just sitting in the seat as a financial advisor. We love people around us, family and sometimes friends. And we get the question often, can I gift money to so-and-so? Friend, family, doesn't really matter who it is. Another individual, you are able to gift, and over the years, this number has increased. So for 2025, it's $19,000 that each individual can give to another individual. And so what does it mean if you are choosing to gift more than that? Well, the first $19,000 that you gift somebody, there is basically no reporting. There's nothing that you need to do. If you gift more than $19,000, the IRS would like you to keep track of that. And you keep track of it through IRS Form 709. And it's just an accounting, a record that the IRS is looking at to say, this is how much money that we've given over a lifetime that exceeds these annual gifting limits. And that lifetime number, again, would have to exceed that same $13.99 million for an individual until an actual gift tax would show up. So a lot of times people are concerned, I want to gift my son or daughter some money for a down payment for a house. It's $50,000. I'm concerned that I might have to pay a gift tax. We'd keep record of it, but most of the time, unless we're gifting quite a bit of money, you're excluded from that and don't actually have to pay the tax. So.
Yeah, so it's essentially it's a unified credit. It's during your lifetime and after. The total is not supposed to be more than this number. So if you gave away $19,000, you don't have to do any reporting. If you gave away 20, you're supposed to report it, and then this number goes down to 13.98 920 or 9880, right? So they keep track of it and they take that off your total limit if you have to report, but there's no tax on it. It's just keeping a tally, right? So if I gave away $1 million, well, now it's down to 12.99 million remaining that I could give away.
So when you say per person, that means anybody?
The question is, so when you say per person, does that mean anybody or a family member? So the 19,000, for example, because this comes up a lot with gifting for real estate or whatever it may be, you can get creative if it's you and a partner gifting to maybe one person and even another partner in that scenario. So for example, if let's say my wife and I wanted to gift our daughter some money, I can give my daughter 19,000. My wife can give my daughter 19,000. I can give my son-in-law 19,000. My wife can give my son-in-law 19,000. So you can get creative if there's multiple people. Yep, that's right. Yep.
Well, you can give more than the 19,000.
Correct.
Yeah, there's just no reporting.
Correct. Per person, per gift, right. So the term unlimited marital deduction, if this ever comes up, what it's saying is if you pass away and your assets happen to exceed that 13.99 million or whatever it may be in the future, there is not a gift or estate tax in that scenario if it's going to a spouse. And so obviously, ultimately, if that spouse ends up passing in the future, you want to do some additional planning if you're over this number to try and avoid the next person from having that tax. So go ahead.
There's also something called portability election, which if you're a combined estate, let's say that you've got 13.99 that you can give away, your spouse has 13.99 that they can give away, you can choose to carry over their exemption limit after they die. You have to file the right kind of forms at the IRS and do it in a timely manner, but there is a way to retain that spouse's exemption limit after they pass away. So for example, you could pass, $10 million could pass to you from your spouse. It's an unlimited exemption limit, but if you want to then pass on more than 13.99, say there's 23 million, you can elect to port that over to keep it for future distributions. So just some tax planning strategies that you'd be able to talk to if you're blessed to be in that category. Then you could talk to your financial advisor, your CPA, and your attorney about how to manage that.
Yeah, this is not a presentation about long-term care, so we're not going to go very deep into this. We just threw this slide in here as a consideration when you're thinking about your estate plan. Definitely planning for long-term care needs is a conversation that you need to have with your attorney to make sure that the right provisions are put in there. There are potential tax benefits too, depending on how things are structured. But again, it's more of a conversation for later for long-term care.
Okay, so so we're gonna talk a little bit about some, just I guess they call it here basic distribution techniques, right? So there's different ways to pass assets on to people after you've passed away, right? So so when I talk to clients, I talk to them. There's an estate plan, which is a set of documents that we would put together for preparation and trying to have those for both during your lifetime and after. But there's also things like beneficiary designations, potentially joint tenancy arrangements. There's other things more globally that are part of estate planning, right? So estate plan is a set of documents, but estate planning may involve other types of distribution techniques, I guess we call them. So back here, so the number one choice that you can make is to do nothing, right? So doing nothing, right? And that's, I mean, a lot of people choose to do nothing, and it's not because they don't want to do anything. I mean, we're busy. We've got lots of things going on where sometimes it's just a matter of, all of a sudden, oh, wow, I'm 50 and I don't have an estate plan. What was I thinking, right? So, or I'm 70 or whatever it is, right? So, you are considered to be intestate if you don't have a plan. That means you don't have a testamentary document. So intestacy basically is one option, which I'm not recommending, but it is an option. A will is another option, which is, I think, superior to having no plan in most cases. Jointly held property and beneficiary designations, right? Other options. So I'm going to move us forward here. All right, so we've talked a little bit about this already, so I won't belabor these points, but problems with intestacy is that it defaults to the probate code for California. That determines how things are going to get distributed, whether it's to a spouse or children, or a spouse and combination of children, or to parents or siblings or nieces and nephews. There's kind of a flow chart of how things can go depending on who survives you. There's primarily what you run into because most of us are not in the, at this point, $28 million plus category. You're not going to run into a lot of estate and gift tax issues, but you are going to run into probate fees and costs and time. And if you have minor children, then you don't have any input into who you would want to have as guardians for them. Will, superior to no plan in that it does allow you to determine who you want in charge, how you want things to be distributed. And you can put some provisions in a will that can extend the management of assets. But one of the sort of, I guess, shortcomings of a will in many cases is if you own certain types of assets, it's still going to require some form of court process to confirm those assets to be moved over to your beneficiaries that you've selected. Okay, so better, but it still has some shortcomings to it. And then joint tenancy arrangements. So did you want to?
I should probably be on that side.
Oh, okay. All right. Here we are. Okay. We're learning to coordinate this. Okay. So so I think one more back. Let me take a look. Or were you jumping ahead on me? Okay. So we'll go to estate planning documents. So some of the documents that we hope that people have in place, and you need to do these before you lack capacity to do them, are things like durable powers of attorney for financial business affairs, so that you have a trusted agent I mean, usually it starts as if you have a spouse or a significant other, it's going to be that person. But then having successor agents that you feel confidence in that they will manage affairs in a way that's best for you. Medical durable power of attorney. That's in California, advanced healthcare directive. I'm certain that if you've gone to the doctor or the hospital anytime in the last year, they've probably asked you if you have one, right? And so that document is, although it seems very simple, it's a very powerful document in that it gives your selected agents the authority to get access to all of your medical information, to take your records if they need to go to a specialist, ultimately to make decisions if you're unable to communicate what you do or don't want. And so, if you're conscious when you get put in the hospital, then sometimes they'll throw one in front of you and say, hey, you should sign this. But there are times where you may not be able to have the ability to do that. So having those in place ahead of time is preferable. And then a living will is actually in California, that's not a document we typically use. I know in other states they have something called a living will, which is very confusing because we talk about wills and living trusts, but they have a thing called a living will that is for your health care, right? So we don't put together living wills here though. Okay, so go ahead. Okay. So then joint tenancy arrangements are in different states, there are different ways of describing it as well, right? So joint tenancy in California, you will see things typically husband and wife as joint tenants, right? But you can be joint tenants with anybody, right? I mean, it's not limited to a spouse or a significant other. It can be with a friend or a child or what have you. Tenancy by the entirety is not in California. California equivalent to that is community property with right of survivorship is what we call it in California. That's a form of ownership that has certain tax benefits that upon the death of the first spouse, then you get a full step up in basis on the property. So that there's some tax advantages to that.
Question about that. So I often see joint tenancy with rights of survivorship. Is that applicable in California or should it be the common?
Yeah, so
community property.
if it says as joint tenants, that's with right of survivorship, right? So it means the surviving joint tenants or joint tenant is the owner of the property, right? So there's no change of ownership other than that the survivor continues to own it. Tenancy by the entirety is in the other states. I think in Oregon, you might see that. And that's, like I said, that's for a married couple, similar to community property with right of survivorship here in California. And then tenancy in common just means we each own half of this, and my half is my half and your half is your half, but we're not dividing up the property and putting a line down the middle of it. The whole property still, and it called an undivided 1/2 interest, like if there were two people. So we're not dividing up the property, but we each own half separately. So in that case, if you had an estate plan, you could deal with your half, right? So let's say it's a family property and you and a sibling inherited it and you don't want it as joint tenants because you don't like your sibling that much, right? So you have tenancy in common. Your half gets distributed according to your plan. Their half gets distributed according to their plan.
Is it safe to say that that's most common with real estate, or do you see it with other assets too?
So in terms of like in real estate, you're talking about tenancy in common.
Just the tenancy in common, yes.
Yes. That's most common in real estate.
What are some dangers of joint tenancy?
Yeah, so this is kind of one of the things I kind of call it the gambler's choice, right? So there's certain things, right? So it makes sense to own things jointly with your spouse or your significant other, right? I mean, typically, although sometimes you have separate property that you acquired before the marriage, you keep that separate, but during the marriage, that part is joint. Now, when people do things where they think, well, I'm going to just do this very simply. My spouse died. Let's say, use me as an example. I'm going to put my oldest son as a joint tenant on my property. And I know that when I die, he's going to do the right thing, right? He's going to split it up with his brother. It's all going to go great, right? Okay. That could work, right? It might work. That's why I call it the gambler's choice. But my oldest son might have a spouse, right? And that spouse might think, yeah, you know what? I kind of like the idea that, you know, we got that property. That's ours now, right? It's not your brother's. That's ours, right? So then that puts my son in a very difficult position, right? So he's not necessarily legally obligated to do anything because he was the joint tenant. Now he owns it. I died. But he's morally and ethically obligated to do something, but then he has to live with his spouse, right? So those things can create complications that we don't anticipate. The other thing is that you can get tied down to the other joint tenant's liabilities. So if my son that I've added on doesn't pay his spousal support, doesn't pay his child support, doesn't pay his taxes, gets a judgment against him, all that stuff can now be leaned up against my property that I live in that I put him on because I was trying to do a shortcut, right? So when I say it's the gambler's choice, sometimes it works out fine, but not every time, right? And so that's why I just am very caution people to consider the potential consequences before just jumping into that. And the last thing is, if I want him off, he has to agree to it. I can't just kick him off. I gave him half of the property, and I think Dustin will talk about, there's also some tax issues that are part of that as well, right?
That's right. And I even saw this last week where it was a mother and daughter, and the daughter presented the idea to the mother, hey, let's take this property jointly. It's a poor man's will. And I said, that's interesting. I hadn't heard that phrase before. Where'd you hear that? Oh, it was a coworker standing by the water, getting a water at the office. Okay. Probably talk to an estate planning attorney about that rather than a coworker. But had you heard that term before? Poor man's will?
I'm not sure I've heard that exact
Yeah.
term before, but it sounds
Yeah.
about right.
So tell us a little bit about some of the community property laws, or at what point would somebody need to amend or make a change to their plan?
Yeah, so community property laws are going to be, there are certain states in the United States that have community property laws, right? And I think there's 13 of them. And then the rest of them have different varieties of what the relationship is between spouses and property and so forth. So one of the things I'll say is, if you generally are going to relocate to another state, like it's going to become your domicile. You're not just going to visit for a couple months. You're actually moving there. You sold your house in California. You moved to Iowa. I recommend, if you have an estate plan here, that you have it reviewed by an estate planning attorney in that state, just to confirm that there are no differences in the state law that need to be addressed in your documents, right? So in some cases, they might say, it's fine. Everything, we don't have to worry about it. The trust is valid. It's valid in all the other states. It's just that what changes is that it's interpreted under California law, but it's administered under Iowa law, because that's where you will be living when you die, right? So that's, I don't know if that makes sense, but that will be the place that you were living before you died. Okay, so that's one reason to check it out. If you are community property states versus non-community property states, it's worth, if you do change into a jurisdiction that's one or the other, you should have your plan reviewed.
Okay, we've talked a bit about some of the challenges or some of the problems with ways that we can pass on our assets to whomever we are passing them on to. There are some ways outside of your will and trust that do not go through the probate process. They are things that are bound by contracts. It's under contract law, if I'm using the correct term, Mr. Attorney. But these things that you see listed here, life insurance, annuities, pensions, and retirement plans like 401ks, 403bs, 457 deferred comps, all those, 3-number things that they throw at us that are these retirement plans. You always want to make sure that you check your beneficiaries that are on file here, because regardless of what you put in your trust or your will, that part actually doesn't matter. It doesn't matter what you have written down. It's what you have on file with these firms when it comes to paying out like a life insurance policy or an annuity a pension or the retirement plan. So
Yeah, so it's an agreement with whoever manages that plan that upon my death, I've told them I want you to pay this person or these people, right? And so that's part of the more global estate planning that I talked about is anytime you're putting some kind of plan together, always important to review beneficiary designations to make sure they're up to date and that they're the way that you want them. For those of us that have like younger children, you're probably going to have your spouse as a primary beneficiary, but then you might have your trust as a secondary beneficiary because your 3-year-old can't receive these assets, right? So you need some kind of intermediary to be able to manage those assets until they come of age, however old you put in your trust for them to have complete control of things. And then also sometimes just depending on your risk adversity, right? How risk adverse you are. You may put the trust as a final contingent somewhere in there. Just say, hey, if all the wheels come off, at least there's a plan for where this stuff is going to go.
So probate can't touch that?
So probate can't touch that is the question. So if there's a life insurance policy, annuity, what you saw listed there, if there's a beneficiary named, if the beneficiary shows up with a death certificate and goes through the claim process, that money will be paid out to them. Yeah.
It's important that there be a living beneficiary, right? So this is the problem that comes up sometimes is when things aren't reviewed and updated, or there's not a contingent, like a secondary. Sometimes those things do go through probate, but because if there's no living beneficiary to receive it, then it has to go to the heirs of the estate, whoever those people are. Yeah.
So you're saying if it goes to the trust, then the trustee has to show up with the death certificate to file the claim, right?
That's correct. That's correct. Yes.
Can you repeat the question? So live stream.
Oh, I forgot what I just said.
Oh, I think she said, so if the trust were designated as a beneficiary, the trustee would be the one to go and fill out the forms, provide the death certificate, and have the assets distributed through the trust.
And naming trust as beneficiary, especially on these types of accounts, I've had a lot of conversations with a lot of attorneys over the years, and there is some different things that you hear out there. And if you were to do some searching, like, should I name a trust as a beneficiary? There is some conflicting advice that I've seen out there. And it's very important. I've determined what it comes down to is the language within the trust that allows it to be a conduit, or what they call a pass-through trust. That is so important that if you don't have that language, if you're not working with an attorney that specializes in this and knows to put that language there, this is just one area that you definitely don't want to call the guy on the telephone pole because they might miss that.
So not to digress, but when you were talking about the property, if I have property out of state, is it the location of the property or the location of the person?
So the administration of your either trust or your estate would be the location of the person. So the out-of-state properties can be put into a trust that's created in California. So generally, just to maybe not digress too much on that, is I always recommend that if you have an out-of-state property, you have an out-of-state attorney prepare the deeds that are going to go into your trust, because there are different formats and language and filing requirements and so recording requirements. But that property can be placed into a trust that's a California-based trust. Your trustee would still have the authorities to take over and manage that outside of probate. And that's even probably more important. If you have things in multiple states, now you have the potential for multiple probates or ancillary probate proceedings in California and wherever else you have those things.
On this topic of beneficiary designations, I cannot stress this enough, especially if you are in a blended family or if this is a second or maybe third marriage. I can't tell you how many times I've seen an old account that somebody forgot about as a 401k that they started with a previous spouse, and that person passes away. Guess who their beneficiary is? It's whatever was on file 20, 30 years ago when you set it up. Very important to review these things on a regular basis to make sure who your desired beneficiary is listed. There are different types of beneficiary designations. There's typically what you'll hear about is primary, secondary, or often they use the term contingent here. You may even hear tertiary would be the third person next in line. And in addition to the difference between having a primary and a secondary, there's additional language that you can include that says, well, if something were to happen to that person, I either want those assets to go to their family or I want it to be distributed to the other beneficiaries. So I'll give you an example. I have two children. Say I name both of them as my, take a step back. Let's say my wife is my primary beneficiary, and then I have contingent or secondary beneficiaries, my two children, right? There was a common accident where me, my wife, and my son were to perish. If I had listed per stirpes, this means from the root, it's saying from my son's lineage, his next of kin would be the beneficiaries. And so there's additional language that you can add to your beneficiaries, whether you have that up to date now or reviewed that and decided you wanted to make a change. Wherever your accounts are, your providers should be able to put this language on there to be able to see whatever your wishes are through.
Has that been like that? What you're talking about? I remember doing that in the little trust.
The question was, has it been like this for a while? I can speak to the last 16 years of experience. It has been for me. I don't know if you'd add to that.
So I'm not usually involved in the selections on people's retirement accounts and so forth. So this is kind of secondhand knowledge, but typically there is an option. It's a box that you check that says either I would want it to pass to the surviving issue of that beneficiary, or I want it to stay at the level of my children and just be added to my other child's share. But I'm not sure that that's consistent with all, plans and programs and so forth.
I thought, oh, go ahead.
It says the
Per stirpes. Mhm.
from the root, and what was the other one from? Just.
Oh, per capita, the way that that's set up. In that same example where let's say there was a common accident, something happened to me, my wife, who's my primary beneficiary, and my son. Actually, that's a bad example because it would all go to my daughter in that instance. Oh, no, so that works. Yeah, it would all go to my daughter instead of partially to my daughter, partially to my son's children. That would be a per capita designation on the beneficiary. That's right. I thought of two others that are not listed here. There are two terms out there, POD or TOD. POD means payable on death. TOD is transfer on death. You can check with your bank. Oftentimes a bank will allow you to add a POD or TOD, and same thing with any investment accounts. If you own securities that are outside of a retirement plan, you can put a TOD designation, which means if something were to happen to me, this is who I want the account to transfer to. That also avoids probate. So.
And supersedes the will or trust.
Yeah, so a beneficiary or transfer on death designation is going to supersede anything that's in a will or a trust. That's a third-party contract with that provider, and they will say, okay, it says to pay Mike, I'm going to pay Mike. It doesn't matter what Kevin's trust says. Okay, so we're at trust strategies.
Yes. So what is a trust?
Okay, so we talked a lot about trust in the abstract here. So I mean, a trust is actually it really is an agreement either between yourself or between yourself and your spouse or your significant other that you are going to hold certain assets. Instead of in your name as an individual or as individuals, you're going to hold them in your names as trustees. And so by making that fine distinction, that asset does not become part of your estate because you don't actually own it, right? Your trustee, which is you, owns it, right? And so, and that allows for, I'll just call it continuity of ownership upon your death or the surviving spouse's death with the successor trustee. So the successor trustee's ownership continues because it's in the trust. And so there's paperwork that successor trustee has to put together and confirm that ownership. But that's the trust structure is set up. And so typically the way it is you as the settlor create a trust, you appoint yourself as trustee, and during your lifetime, you're the beneficiary of all the assets that are in that trust. So it's a little strange, but you manage those assets. So I'd say, you know what, Kevin, I think I want to take some money out of that account and go on a trip to Hawaii. And trustee Kevin says, you know what, beneficiary Kevin, that's a great idea. I'm gonna write that check, and you're gonna go to Hawaii, right? So it's a little strange, but the structure is set up specifically for the purpose, for most of us, of avoiding the court system upon our passing. And so that trust, actually, right, we've got our graphic here.
Question for you. You use the term settler, and I've also heard grantor. Is there a difference in the two?
Yeah, so no difference. It's just kind of a drafting preference of the attorney that you work with. So there's grantor, settlor, trustor. I've even seen trust maker. So I mean, it's all synonymous for the person who creates, or the people who create that trust agreement. So then, yeah, so certain assets get put into the trust, right? And then the trustee manages those. And during your lifetime, you're the beneficiary. After your lifetime, it's the beneficiaries that you've selected to be receiving those assets.
And then also after your lifetime, let's say you're initially the trustee, the term successor trustee you hear a lot is saying, this is who is going to succeed me once I'm not here, or my co-trustee. In my example, say my wife and I, we have a list of successor trustees in order of folks that we know, like, and trust to carry out our wishes. Those people do not necessarily have to be your beneficiaries. You can have a trustee that's a person. There are also companies that act as what they call a corporate trustee. There are trust departments at many banks. They can step in and act on your behalf as a trustee for you. And I've seen that work very successfully as well. When you're getting an unbiased third party that's saying, hey, we're carrying out the family's wishes. Here's the instructions that they left us. This is what we're going to carry out. So.
And is that including like a joint trustee? I mean, or is that even a thing?
So
The question is that including a joint trustee?
yeah. So we would typically identify co-trustees, right? So yeah, the terminology is usually
The terminology is great
yeah.
because you can get really stuck.
Yeah, yes.
Terminology.
Yeah.
So usually if it's a trust that's created with the spouse, the spouses would be co-trustees, right? Yeah, I mean, you could use the term joint, but the most common you're going to see is co-trustees. So then the surviving spouse or the spouse with capacity would continue to act as the sole trustee. When neither spouse can act as trustee, that's when we have a successor trustee, and it could be a successor co-trustees if you wanted to appoint co-trustees. So it would be your choice as to who you wanted to be in charge. And so, as Dustin said, that trustee may not be a beneficiary. They are once the creators of the trust have died. Most of the time, we're working with revocable trusts. Once the creators have died, it becomes an irrevocable trust. That means it can't be amended or changed once the creators are no longer living. And so, yeah. And so, yes, Mike.
There's a question, can a trustee be a family member?
So yes. And that's very common that a trustee would be a family member. And if you have adult children, usually it's one or more of them and a succession of those children if you have multiple children. But not always. I mean, I have clients that have children that they don't want their children to have the burden of having to deal with the administration of the trust. Because I will just say this, trustee, successor trustee is not a prize, it's a job, okay? And so, and they will say, you know what, I'd rather have a professional fiduciary do this. That way my kids don't have to worry about it, right? So that's an option as well.
One other question was, can you define what the executor of a trust is?
Yeah, so executor is typically not a term that's used in describing a trust. So usually we're talking about the trustees, co-trustees, successor trustees. Executor is a term that's typically used with a will. So the executor is the person that is appointed to manage assets associated with the will. I'll just go a little bit further into that. If you have a trust, typically you still have a will. That will is there to usually manage your personal tangible property. You know, we don't put your TV and your jewelry and your bicycle and, you know, even like your cars, usually we don't title those into the trust, right? But the will is, it's often called a pour over will. And so it just says, hey, if I have a spouse that survives me, I'm leaving that stuff to my spouse. If not, I leave it to the trustee of the trust then acting to distribute according to the terms of the trust. So it pours that stuff over into the pool of trust assets and they get distributed that way. So executor and successor trustee are often the same person. So they're taking it out of their executor hand and putting it into their trustee hand, right? But it's a different terminology. All right, so we've been talking about a living trust in this instance, right? Typically, for most of us, we'd be setting up a revocable trust during our lifetimes to manage assets during our lifetimes and after. There are what are called testamentary trusts. You know, they can be put in in a will. The will establishes a trust, right? So it's a little different structure. I don't see a lot of testamentary trusts for most people because a testamentary trust still is in a will that has to go through probate. And so most of the times we're trying to keep things out of probate, right? So, but sometimes when people have assets that maybe they're not, they don't have enough assets to worry about probate, right? Probate has certain asset limits. And so they might put together a will that has instructions and maybe it's an all cash type situation, right? There's no real property involved. That's when maybe a testamentary trust could make sense because then you could establish a trust like for minor beneficiaries with some distribution plan as they get older. But testamentary trusts are basically your will sits there waiting till you die. It's not an active document. It's just saying, okay, Kevin, I'm waiting for you to die. All right, now you're dead. Now the will, I'm going to come into effect and we're going to establish this trust, right? Versus a living trust where it's like, it springs to life when you sign it and you create it and it's an active living document. So we've primarily been talking about revocable trusts. So irrevocable trusts are, there's different types of irrevocable trusts, but the name is pretty accurate, right? So revocable trust means you can revoke it, you can amend it, you can make whatever changes you feel are appropriate. Irrevocable trusts can't be revoked. And they can only be changed with certain circumstances and requirements. A lot of times there will be someone called a trust protector that has the ability to step in and make changes if there's changes in the law or if a trustee is not doing things the way they're supposed to be doing. The use for irrevocable trusts, I guess for sometimes it's a minor beneficiary that's received a distribution from another trust. That's an irrevocable trust, right? Because that trust is established for that minor beneficiary. It's going to be managed until they reach a certain age and then it gets distributed out to them.
Is it safe to say that most folks that are still here and living and beneath those estate tax limits we talked about earlier, the multiple millions of dollars, start off with a revocable, meaning changeable, I can still change it while I'm alive type trust, and then at death, it becomes irrevocable, is that right?
That is correct. Yeah, and that's the most common setup. Oh.
What I wanted to ask is, say, you know, a married couple, one of them dies, right? Can the other spouse change it? Will it go into a revocable trust then? No, because the other one is alive, correct?
Yeah, so I'll have to say it depends on what the trust says, right? So in some cases, it is amendable and revocable during the lifetime of either spouse, right? In some cases, the trust may have a structure that says, well, when the first spouse dies, we're going to put half of this into an irrevocable trust. And that could be for estate tax purposes, or it could be it's a blended family. And that spouse wants to make sure that they're providing for their children. And so it could say half of it becomes irrevocable. Most commonly, it continues to be amendable and revocable during the lifetime of either spouse, though.
So we have to go back, I have to go, because I have been with us, so I gotta go back to my lawyer and look at that, see if that's in there or not. That she can change it, my wife, if I pass away, or she dies away, is that what you're saying?
So if you're not sure, and if reading through it, you don't see for sure that you understand that it does or does not do that, I would recommend that you
What would it say?
review it.
There's some certain wording in there that says that.
Yeah, so there should be a section about amendment
Okay.
and revocation. I would look at that section and read it.
All right.
And then if you're not certain, I do recommend you talk to your attorney to make sure that they explain it to you.
While we're talking about amendments, sometimes people can have reservations about that, whether it be cost or the time or the effort. I would encourage you to, it's stinking thinking. If you have a change that you want, go ahead and make the change. The key word is revocable. It is changeable. You can update it. You could also change your mind. So if there's something you feel like you're really wanting to do, let's make that amendment. And then you could also make another change in the future while you're still here. Do you have a question?
We had a question, and I'll ask on their behalf. It's an individual who's he has power of attorney over the finances and medical condition of his father who had a stroke, and wants to know if he can create a trust on his father's behalf. I think you covered it, but I'll let you answer it again.
So it depends on what the power of attorney says. Again, I mean, if the power of attorney has language in there that says that the agent can establish revocable or irrevocable trust on behalf of the principal, then maybe, I mean, it's not something I can say an absolute yes or no.
Yeah.
I would say probably want to have that reviewed by the attorney who drafted it. To start with would be my first recommendation, because they know their document and they would be able to answer that question easily, as opposed to someone who didn't draft it.
We've got a couple more trusts here now.
Yeah, so a special needs trust is another form of irrevocable trust, right? That's fairly common. And that's being established, usually because we don't want for special needs beneficiaries to lose eligibility for assistance that they're entitled to based upon their disability. Oh, okay. Okay, we're doing the relay. Okay, all right. So we don't want to, I mean, sometimes it seems like a great thing. I'm going to get $250,000 from a life insurance payout, but not if it means that I lose all of the benefits that I'm receiving to help with my particular disability, right? So in the case of that, you would have a special needs trust where there's a trustee that's set up to manage assets for that special needs beneficiary, with specific instructions that say you're not supposed to do anything that renders this beneficiary ineligible for the assistance that they're receiving. It's to supplement, not to supplant the programs that they're receiving assistance from, right? So it's an irrevocable trust, and then there's different kinds of special needs trusts. We don't need to get into that, but that's the purpose. And then incentive trusts. I mean, I think any trust, any revocable trust or irrevocable trust, can have language in it with certain milestones that, upon achieving a certain degree or upon, or encouraging charitable activities or so forth, that you would want your beneficiary to achieve or participate in as milestones for receiving, portions of or all of their distribution.
Yeah, estate plan should definitely be reviewed on a regular basis, but what does that mean? How often is it safe to sit down and review your plan? Would you say annually, every couple of years, or is it another, it depends category? Anytime there's a big event that changes in your circumstances?
Yeah, so it is another it depends situation in that I think what I've been recommending, not so much for your estate plan, but for having some kind of I'm going to say like like a net sheet that has all of your assets on a spreadsheet, the primary asset, the accounts, the properties, the business interests, maybe the major credit cards that you use, and the basic information on those things. So that's the kind of thing that you could review annually when you're doing your taxes, just to make sure, has anything changed? Do I have another life insurance policy that I need to put on here? That kind of thing. And that's to help whoever takes over have reduce the stress of do I know everything that's out there? Do I have to wait for 60 days a month to see if there's something that I don't know about? So that's kind of like an annual thing. That's just an asset review, right? You don't necessarily need to do that. You don't need to do that with an attorney. You might want to do it with your financial advisor and or your CPA. Now, major life events. Somebody dies. You have more grandkids that you want to provide for, things that happen where you think, okay, this would be, I want to make some changes, right? So then you would do a review. And then sometimes you're in a stage of life where, your kids are 5, 7, and 9. You put together an estate plan and nothing's going to change till they're all over 25, right? I mean, it could be like it's 10 or 15 years till something really needs to change. But I would recommend you maybe at least every 2 or 3 years that you at least dust off the plan, take a look at it, make sure everything's the way it's supposed to be. If it's good, put it back on the shelf. And question.
If somebody is in real estate, how often would you suggest they do the same if they're acquiring properties on a fairly regular basis?
Yeah, so now we're kind of at the sort of, I guess, parsing between making changes and adding or taking assets out of a trust, right? So if you're acquiring more and more real estate, then you want to make sure that those assets are titled into the trust, right? So that, and you can do that through escrow. You can tell the escrow officer, hey, how do you want to take title? I want to take title as Kevin, trustee of Kevin's trust. So when that deed gets recorded, it's in my trust, right? So you don't necessarily need to go talk to anybody about that. You just want to make sure that it's titled correctly. And if you want to sell something, you just sell it. The difference is I sign it as Kevin, trustee of the Kevin Trust, not Kevin, right? But in terms of your overall planning, depending on how the growth of your estate, there may need to be some more complicated planning related to the estate, maybe business entities, that sort of thing that you would want to talk to an attorney about. So I'm not saying don't, but it again would depend on what we're doing.
When you mentioned putting the new property in the trust, that reminded me of something that I've seen a number of times. As somebody goes through the process of creating a trust, their wills, the power of attorneys, etc., and then they never fund the trust. Can you talk about funding a little bit?
Yeah, I mean, funding is just titling the right assets into the trust, right? And so now that can happen. It should happen during your lifetime for certain assets. There could be assets that get pushed into the trust after you've died, right? For example, you have minor children, the life insurance proceeds might get pushed into the trust upon your death, those kinds of things. Yeah, it's really, you want to make sure that the right assets get put in there. You want to make sure that you have the beneficiary designations that need to be on other kinds of assets. And then some things like, we don't put everything in the trust, but we try to plan to keep everything out of the court system, right? Yeah.
Yeah, very well said. Thank you.
A quick question. I think we got a question regarding account numbers. I think what they're asking is that if you have an account, I think it goes back to what you said earlier, you have to make sure that you put that account in the name of the trust. correct?
right. Yeah, certain account types.
Yes.
Right, earlier we talked about the TOD, POD,
Exactly.
retirement plans, life insurance passed by contract, but all the other regular checking and savings and, money market accounts,
Correct.
et cetera. And then securities too that are outside of your retirement account. When I say securities, stocks, bonds, ETFs, mutual funds, all those things that are outside of your normal bank and checking account, you definitely want to put those in the trust too. Yes, so a POD means on death, and TOD means transfer on death. The way I've seen it, typically TOD is referring to those non-savings and checking accounts, your stocks, bonds, mutual funds, ETFs, et cetera, and then your bank accounts payable on death, typically. That's where the POD comes in. And TOD is transfer on death. Uh-huh. So we're at that point where we've brought some education, and hopefully this has been helpful to you. You have some choices on how you move forward with your own personal plan. You can do it yourself, or don't do that. Don't do that.
Yeah. So I would say, at least talk to somebody about the plans, more specifically about your circumstances. We've given you a lot of information, a lot of general information, and not all of that may apply to your situation. There may be other things that we didn't talk about that do apply to your situation. And so, it's a very personal thing, and sometimes it's difficult to talk about the idea that what's going to happen if I'm incapacitated or when I die. Those aren't really fun conversations, but so finding someone that you're comfortable with, if you have an attorney that you work with, please, I would say, talk to that person and update your documents if you have documents, if you need to, work on getting documents established if you need to do that.
Great. Thank you. That's very good advice. Speaking for MoneyWise, we have a three-pronged approach at MoneyWise, where today, obviously, we're talking about estate planning, and how that E jumped down there is beyond me, because earlier it looked correct. So we deal with estats apparently now, that we're consistently talking with our clients about much more than just the top one, wealth management, which is your typical investment management and financial planning advice. We see it as a three-pronged approach, which often means we're bringing in other professionals like Kevin, who we're very grateful for sharing this time with us today on estate planning. And look, in the future, we'll be discussing some tax planning and retirement and some other exciting workshops that are coming down the pike. Safe1's always looking to provide education complimentary, and we appreciate being able to be invited and come help with that. So.
Yeah, so I look at that slide there, if you pull that up, and it's so this is fun, right? I mean, wealth, that's really fun to talk about. Tax, not as fun. Estate, a little less fun, right? So I'm usually the last person that people come to talk to. So then down here would be, like green lawn, right? So I'm usually someone comes from a financial advisor that says, hey, you've got all this great stuff. We've done this tax planning. Do you have an estate plan? And then they usually, that's when people come and talk to me. So definitely good to talk to the wealth management people first, to get that together, because that's what's important to you right now, immediately.
Certainly a good financial planner and advisor can help you bring the complications of all these different things, looking at risk management well beyond just the estate plan. So we had a question here.
Yes, you said that $250 was kind of crazy number for to get a estate. Is there like an average price, or what would be the price or the cost, I should say?
Fantastic question. What does it cost to have an estate plan done? And when I say estate plan, yes, I'm typically thinking of a will, trust, power of attorneys, the medical directives, everything, where you're controlling, what happens with the assets, but also what happens while I'm still alive, right?
Yeah. So it varies depending on the complexity of the estate, for sure. For most standard I'm gonna say standard, so non, problematic type of estates, it's probably in the, somewhere between $2,000 and $4,000, right? Would be my, I can't speak for all attorneys in this town. And if you go out of this town, it's probably double that, right? So, I mean, certain places, right? You go to the big cities. For really complex estates, I mean, it's just hard to say because there might be some business entity planning that's involved with that, trying to structure some liability protections. And so it could expand. It could be part of estate planning, but it could expand beyond that, just those specific documents.
Is it safe to say that in the future, if somebody goes through that process and they want to make a change or an amendment, is the term we've heard, that's a nominal charge. It's usually very affordable and low cost to make changes. That way there's not a it's not cost prohibitive to make changes is what I'm trying to say.
It's not cost prohibitive. I wouldn't call it, most of the people that come through don't think it's nominal when the cost, right? I mean, so it depends on the nature and extent of the changes. And so, but if it's well drafted, I mean, you shouldn't need to do changes, every year or every couple years even, right? So, I mean, if you've got a plan that's solid for, I usually say, call it a 5-year business plan, right? So if you have a plan that's solid for 5 years, and then you need to invest a little more money into it to kind of clean it up and get it, updated, it's not usually going to cost as much as it costs to put the plan together, but there will be expenses.
Very good.
We have a few minutes. Oh, here's a question. Yeah. If there's any other questions, just raise your hand.
Is there a difference in tax between probate, will, and estate when it transfer properties?
So I'm not sure. There are so many different kinds of taxes. It'd be, and I'm not a tax advisor, but I'll say, as far as estate taxes go, that's the same regardless of whether it goes through probate or goes through a trust. There's no difference in the limits. And then, but there's so many other different possibilities that it'd be hard for me to answer that.
Yeah, I wouldn't think of the, say that again? Question is there a capital gain on capital gains tax on a house if I gift it to the kids? So I'm going to give you a very common scenario where, let's say we have a 2-partner household. In this example, a husband and wife, one of them passes away. If, let's say, they bought the house for $250,000, when one of them passes away, it's worth $500,000. In a community property state like California, we have what's called a full step up in basis. In that scenario on capital assets, so things like real estate, securities that you own, you get a full step up is what they call it. In the event that step up in the cost basis, which means it's the value of the property on that date of death is the way they look at that. So that would be for a spouse. And then let's say that same $500,000 house, the surviving spouse lives there, it grows to $600,000 and they pass. That gets another step up before being passed to the kids most of the time. And that's where that poor man's will that came up earlier from the review I had last week. The CPA said, you just threw a wrench in that step up by having joint ownership with somebody that's not your spouse. So, this is just one example of getting in front of a professional like Kevin and getting a good plan in place.
We have a question right here.
If you took advantage of the gift tax, does that lower the amount of your gross income that would be taxed that year? And if it does, don't you need some kind of documentation to show that?
So with the gifting, earlier when we were talking about the $19,000 that you can gift, I'll give you an example. Let's say a single person makes a gift to another individual, just a one-time gift of $30,000. The 19 is there's no issue with whatsoever. The extra 11 triggers the need to file a Form 709 with the IRS, where you're just reporting that you made a gift above that free amount. But as long as you're not gifting, multiple millions of dollars, you're likely not going to have an actual gift or estate tax. It's in the same category the gift and estate taxes are looking at that same $13.99 million. So even when it potentially reverts back here in a few years, that number is going to be still multiple millions of dollars before you'd have any kind of gift or estate tax. Like I say, likely as in most of us probably in here aren't giving $28 million away is what I meant by that. Yeah. But if you're in that category, definitely need a good estate plan because there are strategies to avoid the estate tax in that example.
We have a question right here.
Return to his question over there. I don't think you answered it the way he was asking. I'm thinking if you have an income tax debt that you got to pay IRS 6,000, you gift away 10, does that reduce your tax benefit?
You're right. I didn't answer. Thank you for that. No, it does not change your income for the year. It's strictly an accounting of the fact that you've given a gift. Does not impact your taxes at all.
We had a question from the audience. A woman gets married, so her last name changes to her husband's name. Should she change the name on the deed of the property they have before changing it on the trust or simultaneously?
Yeah, so there's a lot of different scenarios, but I'm gonna take this to mean that two people owned a property together before they got married. And so they may have taken title as an unmarried man as his sole and separate property and an unmarried woman as her separate property. And so then when they do get married, if they're going to establish an estate plan, then they would want to update the title to be accurate, right?
Yeah.
So it would be most likely husband and wife as community property with right of survivorship, and then there'd be a subsequent transfer if they were to create a trust into their trust as trustees of their trust. Yeah.
In this case, this individual owned it alone.
Okay. So if they owned it alone, then there's a lot of considerations that they would want to talk about, which I probably can't really get into the details right now because there's some family law issues, there's some separate property issues that I do think they should talk to somebody about how they want to manage it, but I couldn't tell them specifically what they should do.
Okay.
These have been great questions.
Yeah. Any other questions? Yes.
When you retire and you start having RMDs, does that trigger every year a complete review of your estate plan, or can that be incorporated within the estate planning?
So I think that would be a great conversation to have with the investment provider, whoever that is. And there are different strategies on the tax side of things that can come into play, like a QCD, qualified charitable distribution, is one tax strategy. Prior to RMDs, you can look at Roth conversions and other strategies, but I don't know that would be a trigger just because of RMDs to have to revise the estate plan. Question is, who made the decision to make us pay taxes on that money? It's and they want you to pay taxes on it is why they're having you take it. And so
that's a whole other
Yeah.
workshop.
it is.
It wasn't us.
Yeah.
But thank you all for coming.
Yeah.
Hopefully you saw some value here and
Yes, thank
wish
you
all
all.
the best.
Appreciate it.